The 2009 Victorian bushfires, known as Black Saturday, burnt over 450,000 hectares and ranged across the state from Beechworth in the northeast to Horsham in the west to Pomboneet in the southwest. The fires resulted in 6 distinct class action or group proceedings in the Supreme Court of Victoria. The largest of these class actions, arising out of the Kilmore East-Kinglake fire, commenced trial on March 4, 2013. In these proceedings, claims were brought against the owner of the power line whose failure had ignited the fire, a maintenance contractor, and various entities of the state of Victoria responsible for the management of forest lands and emergency management. On July 15, 2014, after a 208-day trial before Justice Jack Forrest, the parties agreed to a settlement without admission of liability worth $494 million, the largest in Australian legal history. In his December 2014 judgment approving the settlement, Justice Robert Osborne noted the fire's toll: 119 deaths, more than 1,000 serious injuries, and almost 1,800 homes and properties destroyed or damaged. The scale of the disaster was reflected in the size of the legal proceedings. Over 5,800 individuals were included in the claimant group. Over 22,000 documents were loaded into the electronic court book for the trial, and some 10,300 were eventually tendered in evidence. In addition to 60 lay witnesses, 40 experts in mechanical engineering and other fields were called to give evidence in relation to the cause of the fire. The management of the volume and complexity of the expert evidence was one of the key challenges for the court and participants in the Kilmore East-Kinglake trial. The Supreme Court played an active role in this task, with judicial involvement in the pre-trial management of expert witnesses and supervision of 11 expert conclaves. During the trial, expert evidence was given concurrently, and Justice Forrest appointed expert assessors to assist him in evaluating the technical evidence. Following settlement of the proceeding, the court commissioned independent research into the way these issues were addressed in the context of the Kilmore East-Kinglake trial. This research records the approach taken and highlights lessons to be learned for the future conduct of large-scale and other litigation. The results of this research are now available online.